Abdallah is Associate Legal Outreach Officer at the International Criminal Court based in The Hague in the Netherlands. Dr. El Abdallah has studied law at the Sagesse University and the Lebanese University, and he obtained his PhD from the University Paris II Panthéon-Assas in Paris. Prior to obtaining his position at the ICC, Dr. El Abdallah taught at the International Business Law Institute in Cairo and at the Panthéon-Assas University in Paris. Since taking his position at the ICC in 2008, Dr. El Abdallah has committed himself to increasing awareness of the ICC's mandate and its importance to the international community. So the lecture that he will be giving today is part of that endeavor, and he will be trying to help us understanding the ICC, its mandate, its scope, and its relevance for the Arab region. Let me mention that this lecture is organized is part of the I5's UN in the Middle East Research Initiative. I think this trying to help us understanding better the ICC is definitely an important undertaking, as there is without doubt some confusion about the different international judicial bodies existing today, and one of the challenges I noticed in the introductory class to public international law is to try to explain to the students, to make them understand the difference between the International Criminal Court and the International Court of Justice, and the different. So I think it's challenging, important to try to get some clarity among these different international courts and tribunals. So I would like to thank Dr. El Abdallah for taking the time to discuss these issues with us today. I would like to thank also the audience for resisting the call of a long weekend and choosing to delay it for a few hours. Before leaving the floor to Dr. El Abdallah, I would like to apologize in advance in case a small or little girl just comes in and joins us at some point, because I had to cope with the the fact that my daughter's school closed today on short notice, and that I was asked to introduce our speaker on short notice as well. So, my apologies for any inconvenience and so forth. So thank you for your understanding. Thank you.
So thank you, Professor Hamdawi, for the presentation, and thank you all for coming here. But first, as I understood from you, we need to have a kind of clarification how many international courts, tribunals are there, and why there are different ones. I work at the International Criminal Court, and already by saying criminal, we are making the first distinction. So, for example, the International Court of Justice doesn't deal with criminal issues. It deals only with conflicts between states. Okay? So, criminal is first criteria to speak about International Criminal Court. Criminal means that there are prosecutions for crimes against individuals, not against the states, not against regimes or political parties. Okay? Now, also it's an international court. International by its constitution, because it has been, it is based on a treaty, on an international treaty that was adopted in 1998 at Rome. That's why it's called the Rome Statute. And it has been ratified by 60 states by 2002. That's why the entry in force of this treaty is dated the 1st of July 2002, which means that the court cannot try persons for crimes committed prior to this date. So the jurisdiction of the court deals only with crimes committed after the 1st of July 2002, because it's the date of the entry into force of this treaty. Now, it's also international by its composition. The judges are elected by the states parties. Now there are 111 states parties because Bangladesh is the last one who ratified the Rome Statute a few days ago. So you see that we passed from 60 to 111. So these states parties elect the judges, and they have also to respect in this election a kind of fair distribution among the different regions or areas of the world, but also a fair representation of the different legal regimes in the world, and a fair representation of women and men. And actually, now we have 10 women and 8 men as judges at the court. So this is also part of this international aspect of this court. But also, it's international because its jurisdiction is not limited to a specific region or to a specific country, which makes it different from other tribunals like the Special Tribunal for Lebanon or the international tribunals specifically created for the ex-Yugoslavia or for Rwanda, the specific chambers for Cambodia, for special court for Sierra Leone, etc. All these international tribunals and courts were created for a specific time and for a specific country. That is not the case for the International Criminal Court. The International Criminal Court is the first permanent criminal international court. So it's not limited in time. The crimes prosecuted shall be committed after the 2002, but the International Criminal Court will remain in action indefinitely in the future. So this is a difference between the International Criminal Court and the other international tribunals that are created for a specific time and for a specific country. Okay, so this in general kind of differences between the International Criminal Court and the other courts and tribunals created by the international community, but also there's a specificity of the International Criminal Court that since it's based on a treaty and not on a resolution by the United Nations, which is the case, for example, for the International Court for the ex-Yugoslavia or for Rwanda. And because of this treaty process, that means that in principle the court is has only jurisdiction toward the states that accepted its jurisdiction by ratifying the treaty or by accepting this jurisdiction. There is only one exception, I will mention it later, but it's just when the Security Council defer a situation to the International Criminal Court. This is the only exception about this idea to respect the sovereign decision of the states to join the ICC. Okay. So, why this court has been created? First, because there is a need. There are crimes. There are mass crimes committed, and these mass crimes can be of concern to the whole international community and not only to one country. And if this country is not able to prosecute the perpetrators of these crimes, then the international community has to intervene. So, after the Second World War, specific or special courts were created for the Nazi regime and for the Japanese regime. But of course we can see that it's only a part of the justice that has been achieved there, because it was only for two regimes in this worldwide war. Okay. So after that, everyone realized that there is a need to international criminal court that has a wide world jurisdiction and that is permanent, that is not created ad hoc on specific occasions. But because of the Cold War, everything in the international level was almost paralyzed because of this rivalry. So the idea of International Criminal Court remained as an idea. It's only after 1991, so after the falling of the URSS, that this idea started to live again, and intensive discussions and negotiations took place in New York and then in Rome, in what is called the Conférence de Rome, the Rome Conference, in 1998. And the result was that the states adopted the Rome Statute, the treaty. Of course, it was also an occasion to see how the NGOs can play a very active role in reaching this result. For example, in the Rome Conference, there was about 160 states, but there was almost double this number of NGOs that are active and pushing to achieve compromises and to adopt the Rome Statute. So yes, first there is a need for justice for the victims of these mass crimes, and second, there should be prosecution if the national levels are unable or unwilling to prosecute these perpetrators. So in this case, we need to have another solution other than the national judicial system in order to achieve this justice. So these are important criteria to understand how the court will function. So first, we need to define what are the crimes that are within the jurisdiction of the court, and second, when the court can really exercise its jurisdiction in complete respect of the sovereignty of the states, because it is based on a treaty, it's negotiated by the states, and the states are not very happy with the intervention of international organizations in their own affair unless it's really needed, really necessary. Okay, so first, what are the crimes that are within the jurisdiction of the court? It's not all the types of crimes. I said that it should be committed after the 1st of July 2002, but there are specific types of crimes that are within the jurisdiction of the court, which are war crimes, crimes against humanity, and genocide. For now, I will not enter into more details about what is each type of crime, but just very briefly, crimes against humanity are different type of crimes like murder or like sexual slavery, etc., that are committed during a widespread attack against civilian population. War crimes are committed during an armed conflict, and it's also different kind of crimes like murder, like torture, like pillages, like using child soldiers, for example. But there is another element that should be taken into consideration, which is that these crimes has to be committed based on a plan, on a policy. There is someone who planned the commitment of these crimes on a large scale. So it's not just one person torturing another one and we can speak about war crimes. It should be the policy or the plan of the organization behind it. And the third type of crime is genocide. Genocide is also different type of acts, like the murder, like submitting a specific group to conditions of life calculated to destroy this group, or like the transfer of the children from this group to another group. But the most important element in the definition of the genocide is the specific intent, the genocidal intention of the perpetrator. And this is an intention to destroy a group because of its difference. Its difference of ethnicity, its difference of language, of color, of nationality, of religion, etc. So there is an intention to destroy a group because it has this specificity, this common thing to this group. Okay? So for example, we had a warrant of arrest against al-Bashir that included accusations of war crimes and crimes against humanity, but the judges at the first level did not adopt the charge of genocide because they considered that there is no enough evidence to believe that there is this genocidal intention. Now they are requested to reconsider this judgment about this point, but until now there is no genocidal charge against al-Bashir because the judges are not convinced that there are enough evidence to adopt this charge. Okay. So, among the criteria to open an investigation, we need to see what is the type of crime that is alleged. We need to see when these crimes were committed, so after the 1st of July 2002. We need to see also where or by whom these crimes were committed. Because the court has a jurisdiction over the crimes that are committed on the territory of a state party or by citizens of a state party. So, for example, crimes committed in Lebanon by Lebanese citizens cannot be prosecuted by the court for now because Lebanon is not a state party. So the citizens should be citizens from a state party, or the territory is a territory of a state party. Here also there is two exceptions to this condition. One is when the Security Council refer the situation to the court. As I said, in this case we don't look whether the territory are territory of state party or the citizens accused of the commitment of the crimes are citizens of state party. The court will have jurisdiction over this situation because of the deferral of the Security Council. The other exception is when a state that is not a state party declare accepting the jurisdiction of the court. So make a declaration and send it to the court saying that this state declare accepting the jurisdiction of the court over the crimes that were committed on his territory or by his citizens. This is, for example, the situation of Gaza. Now, I will speak later about that, but just for now, the Palestinian Authority made a declaration to the court saying that they recognize the jurisdiction of the court over what happened in the Palestinian territories since 2002. Now, I will explain to you later what are the other steps about the Palestinian situation in particular. Now, back to the criteria to open an investigation. So we said we need to have crimes committed after the 1st of July 2002. Types of crimes are three for now: war crimes, crimes against humanity, and genocide. There are discussions about the crime of aggression that might reach to an agreement, and if the states parties agree on that, then the court will have jurisdiction over this fourth type of crimes. But for now, there is no jurisdiction over it. So we said also that the crimes should be committed by citizens of state party or on the territory of state party, with the exception that I mentioned. But also there are other criteria. One among them is the complementarity that I already mentioned briefly, saying that complementarity means the court has jurisdiction only if on a national level there is no prosecution, or that the national judicial system is unable or unwilling to prosecute. So it's only if there is no genuine prosecution in on the national level that the court can intervene. This is a point that makes a difference between the ICC and the other international criminal tribunals, because, for example, in the case of Yugoslavia or Rwanda, the priority of jurisdiction was to the international judges, while with the ICC, the primary responsibilities is for the states to prosecute the crimes. It's only when the states are unable or unwilling to do what they have to do that the International Criminal Court will intervene. Another criteria is a criteria called the gravity of crimes. So we have already a decision from the prosecutor about that, saying about some allegations against British soldiers in Iraq that this alleged crimes made between 4 to 12 victims, and this means that it doesn't fulfill the requirement for gravity of crimes. So what is grave crimes or not, it will depend first on the assessment of the prosecutor, and in case he goes to the judges can also reconsider this point. But it's not automatic. It's not just one crime committed somewhere. We are speaking here about mass crimes that justify that international courts intervene in the affairs inside sovereign states. So there should be really good reasons for that. And last criteria is the interest of justice. So to open an investigation, the prosecutor should believe that by opening this investigation, he will be serving the interest of justice. For example, if he can open an investigation for a period of time that covers only the crimes of one party of the conflict, then the prosecutor can say, no, I will not open an investigation here, because serving the interests of justice means prosecuting all the perpetrators from both sides. Of course, the prosecutor will never prosecute all the perpetrators. He will always prosecute only the high responsible. First, because of resources, of limited resources of the court, but also because of the primary responsibility for the state to deal with these issues. So the idea is that the policy of the prosecutor is to prosecute only the persons who bear the most responsibility for these crimes, and by that giving a kind of positive shock, making other prosecutions possible and encouraged on national level. So these are the preconditions. Once, every time that the prosecutor will have to decide whether or not to open an investigation, he needs to look into all these conditions. And of course, if we have a case before the judges, the defense might argue that one of these elements is not fulfilled. So the judges can reconsider the assessment of the prosecutor about this. So these are the conditions now how the court actually open an investigation. When the jurisdiction is triggered. Okay. So there's three types of process possible to trigger the jurisdiction of the court. First one is a referral by a state party. So a state party can ask the prosecutor to open an investigation about a specific situation, even if this situation is not within this state party. So for example, we can imagine if Lebanon was a state party, that Lebanon can ask the prosecutor to open an investigation about what's happening in Afghanistan, because Afghanistan is another state party. It's not only the same government that has to refer the situation to the prosecutor to open an investigation. But actually, what happens in the reality until now is that the governments themselves requested the prosecutor in 3 cases out of 5 to open an investigation. The second process to trigger the jurisdiction is when the Security Council defers a situation to the prosecutor. But in these both situations, so if the deferral is by a state party or by the Security Council, it will be up to the prosecutor to decide whether or not to open an investigation. They are just giving him the possibility to open the investigation, and he has the obligation to reconsider, to examine, and to assess whether or not to open an investigation. The third process is what's called a Proprio Motu investigation, meaning the prosecutor can decide on his own, by his own initiative, to open an investigation in a situation that fulfills all the requirements that I already mentioned. Sorry, but in this case, the prosecutor will have to ask the authorization of the judges. So he has to make a kind of preliminary examination. He sees that there is a reasonable basis to start to open an investigation, and then he needs to present a request to the judges with the evidence that he gathered and that he deems that he has to present to the judges to support his request. And then the judges will have to assess whether or not we should open an investigation. So it's only when the investigation is opened by the own initiative of the prosecutor that he needs this authorization by the judges. If not, if the referral is by state party or by Security Council, we don't need this specific authorization. Now, once the investigation is open, of course, it's normal process. The prosecutor will send investigators, gather reports and evidence. he has the obligation to gather evidence in favor and in disfavor of the suspect. So, and he has the obligation also to transmit, to communicate the exculpatory evidence to the defense. So it's not, the prosecutor cannot gather only the evidence that serves his own case. This is one of the elements that is considered guarantees for a fair trial and for the respect of the rights of the defense. Now, after that, he can ask the judges to issue a warrant of arrest or a summons to appear. Both cases has already occurred. And the judges decide if there is a real reason that makes it necessary to arrest the person, to guarantee that this person will be present at his trial, or to guarantee that he will not be an obstacle to the investigation or will not continue committing the crimes. In these cases, a warrant of arrest can be issued. If not, it will be a summons to appear. After that, the person, whether arrested or not, should appear. Before the court, there is no trial in absentia. We need to have the person in the courtroom in order to start the proceedings. Prior to the trial, there is an initial appearance audience and then a confirmation of charges audience. The initial audience, the initial first appearance audience, is just to make sure that this person is the concerned person, that he understands fully what are the charges against him and what are the language that he will prefer to use in the courtroom, because he has the right to understand all the proceedings that are happening against him. And then the confirmation of charges hearing. The confirmation of charges is a very particular proceedings before the International Criminal Court. It's not often that it's not used in other international courts, at my knowledge. And the idea behind it is to hear for the first time the arguments of the defense, to assess whether or not to go to a trial, because first the judges heard only the position of the prosecutor and the evidence of the prosecutor. And based on that, they issued a warrant of arrest or a summons to appear. But in order to go to a trial with all what it costs in time, in money, and in efforts and resources, reputation, etc., we need to have substantial grounds to believe that this person committed the alleged crimes. So the judges will have to listen to the different parties, plus the victims that can participate in the proceedings, and decide upon examining all these arguments and all this evidence whether or not start the trial. The confirmation of charges will take 2 weeks, 10 days, 1 month, more or less, while a trial will take 1 year maybe, or even more. So in order to economize all the costs, there is this first step, which is the confirmation of charges. At the end of the confirmation of charges hearing, the judges can decide to decline the charges and to put free the person, or to put an end to the proceedings against him, which happened for Abu Garda, who is a Sudanese person who was accused of war crimes by attacking African Union peacekeepers in Darfur. And after the confirmation of charges, the judges decided to decline all the charges and put an end to the proceedings against him. Now the prosecutor is willing to appeal this decision, but meanwhile the person was not in detention and he remains free for now. So, or the judges can decide to confirm the charges in total or in a part of it, or to ask the prosecutor to modify the charges, because they consider that there are other charges that may be confirmed in this, based on this evidence. And after that, there is the trial, which is a very common type of crimes, of trials of crimes with witnesses coming and testifying before the court, with evidence presented, audiovisual material or documents, reports, etc. The main important thing is both in the confirmation of charges and in the trial stage is 2 points. First of it is respect of the rights of defense, and second, the participation of victims, which is the participation of victims before the International Criminal Court is the first of this type that has ever been admitted on international level, before international jurisdiction, the active participation of victims. And we will speak about that, but first, about the right of defense. I mentioned that a suspect or an accused has the right to understand the charges, to understand the proceedings in a language that he fully understands. So there is, in sometimes, a huge effort for translating and interpretation of all what is said in the courtroom, and translation of a lot of documents sometimes. But also there is a right to have the facilities and the time to prepare its defense. So, and this includes not only having counsels, but also all the logistic facilities for these counsels. So if the person does not have enough resources to engage lawyers to present his defense, there is a legal aid program paid by the court that will pay for the lawyers to represent him. But also the court will offer offices, computers, research help. There is a specific units within the registry to support the defense in preparing its defense by doing the research, etc. But also the registry can and has also to help the defense organizing counter investigations on the field, and also protecting the witnesses of the defense, not only of the prosecutor. Okay. So the registry and the judges are organizing the units and organizing the debates in a manner to respect what is called the equality of arms between the prosecution and the defense. This is part of the guarantees of the rights of the defense. Of course, there is the rights not to testify against himself, and the right to remain silent without taking this in his defavor some way. As for the victims, as I said, the participation of victims is a very new point, and it was one of the innovations of the Rome Statute. And the victims can participate in different manners. I'm not speaking only about asking for reparations. They can ask for reparations. And if the person is condemned, then the judges may decide to allow them reparations paid by this suspect or this accused. But the participation of victims is larger than that. The participation of victims includes sending information to the prosecutor, but also presenting evidence directly to the judges. It also includes presenting legal arguments independently of the point of view of the prosecutor or of the defense, asking for testifying themselves in the courtroom on their own account, not called by the prosecutor or by the defense, and also asking questions to the witnesses called by the two parties, the defense or the prosecutor. But in all these rights recognized for the victims are participating only to present their concerns and to protect their or to serve their personal interests. So the victims are not allowed to become a second prosecutor. This is not the purpose of their participation. So even, for example, if the legal representative of victims are willing to ask a question to a witness, they have to ask the authorization of the judges to ask the questions, and the judges will have to assess whether these questions or this line of question is motivated by the personal interest of the victims. It's not they are not looking for the truth in general. They are presenting their concerns and defending their own personal interests. Okay. So just an example about this independent position of the victims. In the first trial before the court, the Lubanga trial, Lubanga is a Congolese person who's prosecuted for war crimes of using child soldiers in military activities, hostilities, in Ituri, in the east part of the Congo. And the victims, by their legal representatives, asked the judges to change the legal qualification, so to add in some way a new qualifications of the facts, saying that it wasn't only enrollment of child soldiers, it was also sexual slavery, for example. And this request by the victims made a big debate, and then the appeals chamber decided about that. But anyway, what's important in this story is that both the defense and the prosecutor were against the victims in the request. Both were willing to stick only to the initial charge of using child soldiers, not speaking about sexual slavery. So the victims were presenting a completely independent position. So this is very important to understand, that this participation of victims is intended to give them a place to make their voice audible in the courtroom, to express themselves, to present their concerns to the judges. Now, this is briefly all how things work. About the structure of the court I can speak very briefly about that. There is the presidency that presents the court and is in charge of the general administration of the court. There are the judges distributed on chambers, 3 types of chambers: pre-trial chambers, trial chambers, and appeals chambers. There is the office of the prosecutor, which is an independent organ of the court with its independent organization. And there is also the registry of the court, which is in charge of different things, mainly giving the logistic support to all parties and participants involved in the trial, but also the protection of the victims and witnesses, the translation, interpretation, the outreach activities and public information, the legal aid programs, and the list of counsel that are admitted to represent persons before the court. Besides that, there is an assembly for the state parties. I mentioned that there is 111 state parties. They are reunited in an assembly. This assembly is a kind of parliament in some way for the court. They adopted the main important documents and rules, their own statute and the rules of procedures and evidence. They can amend these documents. They adopt the budget, and they control how it's spent. They elect the judges, they elect the prosecutor, etc. But also, the states created a trust fund for victims. And this trust fund is an independent entity which is intended to help making projects of general service for the affected communities in the countries where the court is already working. So they started in Uganda, they are now working also in Congo, or they will start very soon. But the idea is that the trust fund for victims does not have to wait until there is a convention of a person to pay reparations. They can, at the moment that there is an investigation that is open, the trust fund for victims can start looking on projects and start working on projects to serve the affected communities by the crimes under investigation. So now, what are the actual situations before the court? What are the cases? What are the trials? Now we have 5 investigations already opened. Congo, Democratic Republic of Congo, Uganda, and Central African Republic. In these 3 situations, it was the governments who asked the prosecutor to open an investigation. We have also the situation in Darfur, in Sudan, and in this case, it was the Security Council who asked the prosecutor to open an investigation. And lastly, we have the situation in Kenya. The prosecutor requested the authorization of the judges to open an investigation about the post-election violences in Kenya in 2008. And yesterday we had a decision granting him this request. So for now we have these 5 situations. Actually there is 2 trials ongoing for 3 Congolese accused, and there is a 3rd trial that will start on the 5th of July. It's for Congolese citizens, but for crimes committed in Central African Republic. There is also the case of Abu Garda that I mentioned. We had a confirmation of charges hearing, and then the judges declined to confirm any. In the Sudanese situation, you already know that there is a warrant of arrest against Omar al-Bashir, the Sudanese president, and there is also 2 other warrants of arrest against Ahmed Haroun, former Minister for Interior Affairs, and now I think Wali of Kordofan, and another warrant of arrest against Ali Kouchet, a presumed Janjaweed militia leader. So this is the actual situation. The prosecutor is also doing what's called a preliminary examination in different situations in Georgia, Colombia, Cote d'Ivoire, Chad, Afghanistan, Palestine, and had already issued 2 decisions about Venezuela and about Iraq, refusing to open an investigation in these cases. First, about Venezuela, the prosecutor considered that there is no enough evidence to qualify some kind of acts of violence there as crimes against humanity. And for Iraq, as I already mentioned to you, Iraq is not a state party and the United States is not a state party. So the prosecutor was only looking about allegations against British soldiers because the UK is a state party. And he said in 2006 that the evidence that he could find at this moment indicated that there is possibly crimes committed and resulted in 4 to 12 victims, and in this case the criteria of gravity is not fulfilled. But he also added that it remains first to the Britain, to the British judicial system to prosecute, because they are able and they are willing to do that. Now for Palestine, I already mentioned to you, there is a declaration by the Palestinian Authority recognizing the jurisdiction of the court. So, first of all, we need to assess whether or not this declaration in itself fulfills the requirements of the Rome Statute. Actually, the Rome Statute speaks about the declaration by a state, which is not the case of the Palestinian Authority. So, this is a kind of obstacle. The position of the prosecutor, as explained in a letter to the High Commissioner for Human Rights, is that we need to assess what is the meaning of state within the Rome Statute. So it's not state as we in general acknowledge it. It's state within the Rome Statute meaning, and for that, as the prosecutor explained in this letter, he requested the Palestinian Authority to provide him with more information about the judicial system, the Palestinian judicial system, considering that maybe the meaning of state in the meaning of Article 12 is an entity that has a judicial system capable of prosecuting and also capable of transferring this jurisdiction to the international level. Okay? So he is trying to examine this point for the moment. And the last thing that I knew is that the prosecutor, the officer of the prosecution, was awaiting for the Palestinian Authority to provide a document about this specific point. So for now, we don't have a decision about Palestine in general, or the Palestinian territories. If the prosecutor decides that the application, the declaration fulfills the requirements of the Rome Statute, And if he decides that there is enough evidence to see that there are war crimes or crimes against humanity or genocide, then he will have to ask the judges the authorization to open an investigation, unless a state party or the Security Council refer to the prosecutor this situation. In this case, there is no need to ask for authorization. But the first element is to see or to know whether or not this application is fulfilling the requirements. So what is the legal value of this declaration made by the Palestinian Authority? So this is kind of presentation about the court. I will be happy now to answer your questions, concerns, and to see how you would like to have a better dialogue with the court, even though we are in The Hague and we are at Beirut, but would very much like to be here in some way.
Dr. El Abdallah told me before his lecture that his job was basically concretely about translating what judges say at the ICC into an understandable, into something understandable for normal people like you and me, which is a challenge that I think the presentation today makes me think that he does indeed possess the skills to, because he was able to give us a clear picture, an understandable picture of a complex institution with many complex legal issues. So thank you so much for that presentation. Before turning to the discussion, I would like to thank also Mr. Ramzi Hori for organizing this lecture, arranging the logistics, and making this lecture actually possible. So thank you very much. And let me mention also again that this lecture is part of this IFI ongoing lectures on UN and related bodies. So we will have more lectures on UN and related topics within the following months. So please, you can follow up on the IFI lectures within that framework. So I suggest that we now start the discussion.
I was hoping you might be able to talk more about the Arab region. I know that only 3 Arab countries have signed up. Why the reluctance in terms of Arab participation in the court? And second of all, what you said about Palestine I find somewhat bizarre, to be honest, because what if the judges decide that they're not going to recognize Palestine? I mean, there are clearly people in Palestine, they might not be recognized as a state, so if they're not recognized, does that mean that all the crimes against Palestinians go ignored? I mean, that makes very little sense to me. Thank you.
Okay, well, I fully understand your concerns, and I think that everyone, including everyone at the court, is very concerned and sensible to any kind of crimes anywhere, not only in Palestine. But you need to understand that as a court, there is legal rules, and the legal rules were not chosen by the judges or by the staff. The legal rules were discussed and negotiated by the states. It is part of the international law, and international law is mainly a law of the states, decided by the states, especially when we are speaking about a treaty-based court. So we need to stick to the rules, and the rules says that, of course, we need to have either a referral by the Security Council or a state party that ratified their own statute, or at least a state that declared accepting the jurisdiction of the court. It's only when we have one of these preconditions that we can start looking into the other elements. of the jurisdiction. So for the Palestinian case, the main issue is to know what the Rome Statute means by a state. So as, for example, Professor Shurdi was saying, it might be a kind of creative solution to see that we can have different meanings of state and then start to look. Or maybe other ideas can be added to this debate. The idea is not to recognize the Palestinians as humans or as persons who suffered from crimes. It's not this. The idea is to see where are the limits of the jurisdiction of the court. And the limits are mainly the 111 states parties and a referral by the Security Council, and eventually a declaration accepting the jurisdiction of the court, a declaration made by a state. So what is a state in this meaning? Yeah. And this is why the prosecutor is looking into this question of the Palestinian judicial system, to see whether or not there can be a kind of transfer of jurisdiction in order to be able to open an investigation. So in all cases, whether or not there is a decision considering that the declaration is fulfilling the requirements or not fulfilling the requirements, it's not about recognizing Palestine as a state in a general meaning, and it's not about recognizing or not that there are crimes. The first decision that should be taken is whether or not the court has enough jurisdiction to open an investigation in this situation. And I need also to remind you that the primary responsibility is to the state. So to the state of Israel, to the Palestinian judicial system, eventually to other judicial systems that might have universal jurisdiction, etc., to prosecute the perpetrators of all sides, of conflicts as important as the Palestinian one. So this is for this part. And for the other question about the Arab region and the Arab states, for now there is only 3 Arab states that are parties to the Rome Statute. There is Jordani, Djibouti, and Comoros. But that does not mean that there is no cooperation with other states. There are cooperation, and sometimes their cooperation is very important for us in order, for example, to bring someone to the Hague, a witness or suspect or etc. Yeah. But on the same time, we cannot judge why the state is not willing to ratify. It's a sovereign decision, and we have to respect it. But I can see a kind of different types of arguments that are used in the debates with or against the ratification of the Rome Statute. And one of them is the question of the relation with the Security Council, so the fear of political interference. The other one is about the crime of aggression. And third one is about relation between the Rome Statute and Sharia rules. Of course, I don't think that deeply there is any contradiction between Sharia and the Rome Statute. But it remains that we need to explain that to the people. Now, for the 2 other points, first for the crime of aggression, the Arab states were very active at the beginning in the preparation for the Rome Conference and in the discussions there, and even Sudan was very active about that. But at some moment, the Arab states were saying that without adopting a definition of the crime of aggression, we will not feel enough secure, because they consider that they are suffering of this kind of crimes, and they want this crime to be prosecuted by the court. Of course, I believe that it would be much more effective to reach an agreement and to vote on it at the end if the Arab states were in the Assembly of States party and not on the outside. But it's a sovereign decision. However, the discussions about the crime of aggression is ongoing. In Kampala, at the end of May of this year, there will be a review conference, which is a very important event for the court and for the Assembly of States parties. And one of the main points on the agenda for this review conference is the crime of aggression. There is a draft of agreement, and we hope that maybe the state parties will reach an agreement about that. Now, the other point that I mentioned is about the relation with the Security Council. Now, the Security Council can defer a situation to the court by a resolution taken under Chapter 7 of the UN Charter. This is a political decision, of course. But, on the same time, it is a political decision made by a kind of large consensus, because you need to have no veto from any of the 5 permanent members, plus a majority of the Security Council, which means that there are some serious reasons to have this agreement on deferring a situation to the International Criminal Court. Okay. But also, this decision should be motivated under the Chapter 7 by the idea of preserving the peace in the region and in the world. So this is also a kind of point of renewing trust in justice as a key factor to reach peace. Okay. But after this resolution by the Security Council, there is nothing that obliges or that imposed to the court to prosecute a specific person or to open or not an investigation. Okay. So all the judicial process is judicial. It's based only on legal criteria. The referral by the Security Council is just an opening the door. But all what happens after that is based only on legal and judicial assessment. So it's not political. Okay. Also, the Security Council can issue a resolution also under the Chapter 7 to delay or to put a hold on the prosecutions or the investigations for only 1 year. And to renew it, the Security Council will have also to have another resolution under the Chapter 7. So as I mentioned before, having this large consensus means that there should be a serious reasons. Okay. Now, is that political? Maybe, but on the same time, it is a political responsibility. Because at the beginning, why these 2 articles in the Rome Statute were adopted? It were adopted because the states themselves wanted to have a kind of a door to a universal jurisdiction, saying that maybe a country, a state that decided not to ratify and then to commit crimes within its territory. How to prosecute in this case? We need to have a kind of guard or security, in French we say soupape. I don't know what is in English, but a kind of safety guard to allow the international justice to do its work, even if the country is not ratifying, is not willing to ratify. But it's only a possibility. The other possibilities that some states are saying, well, the Security Council will never defer our situation. Right? Yes, but we don't need to wait until the Security Council defers it. We can take our destiny in our hand and decide to join ourselves to join the Rome Statute. You don't have to wait until there is a political decision on a different level. Also, the states, while discussing the Rome Statute, they decided to have a kind of another security or safety way by saying that maybe in some times we need, for the sake of peace negotiations, to put on a hold the investigation against a specific person. Okay. So it is a political decision, but it doesn't undermine the judicial path or the judicial proceedings, because it doesn't interfere into the decisions itself of the judges. And the moment that the resolution will arrive to its end, and with no other resolution, then the justice will continue the proceedings from the same point. Okay? And on the same time, well, at least for the Arab states, the Arab and the African states asked the Security Council to adopt a resolution to stop the prosecution against Omar al-Bashir. So I think they are recognizing and they are willing to apply this article, Article 16 of the Rome Statute. And in my opinion, it's not very coherent to complain about having the Article 16 and to ask to use it. on the same time. So, but these are arguments in the debates about the ratification of the Rome Statute. I think, in my personal opinion, that the main obstacle and the most important is that there is not enough knowledge about the court, meaning that the people, the deciders, and the media and the general public opinion are not enough aware of the court and how it works, what are the safety guards, what are the guarantees of the independence of the judges, etc., in order to have enough trust to join the court. And this is mainly, this is part of our job at the public information section. Of course, our priorities is the situations where the investigations are already open, but we are trying to help the NGOs, the media, the legal community, the academic community in the different countries, to help them to reach the source of information if they are willing, and to help them to better understanding the ICC. And I believe that this is an important point that might change the perception of the court. The other point is more interacting with the media. And the third one is a diplomatic level, and we are late, but we are starting to work about this diplomatic level of discussions.
Thank you. I'd like to, I was curious, considering the case in Kenya. Kenya, yeah. It wasn't the Kenyan government that called upon the ICC. In fact, if anything, it was the Kenyans themselves that might welcome the ICC's involvement. I mean, this morning a press release by the chief executive kept stressing on witness protection. And so where do you see this going? I mean, considering it wasn't the government themselves that asked for the ICC to get involved. I mean, might it cause more instability in the nation?
I think I see your point, but on the same time, I remember several meetings between the prosecutor and the Kenyan authorities, and the position of the prosecutor is that in Kenya we can have different types of proceedings on the same time, different approaches, and all this will be complementary one to the other in order to reach a better justice. So he was saying that the ICC can prosecute the high responsible of these crimes, and that on the national levels there can be prosecution and there can be also reconciliation commissions, for example. So the idea is to join the efforts from different types. Now, the authorities, the Kenyan authorities, were engaged to cooperate with the court about that. It's true that they didn't refer the situation to the court, but they mentioned several times they're willing to cooperate with the court, and anyway, they have the legal obligation to cooperate with the court because Kenya is a state party.
Dr. Fadi, this is the main problem in terms of what's happening in complementarity, is that the ICC Rome Statute envisages that the ICC should encourage national prosecution. So practically, the philosophical grounds of complementarity is to encourage national courts to do the business, and when they are unwilling or unable, not. Now, in my opinion, that brings in the issue of inaction, and which is that prosecutors consider that these are uncontested, admissible cases, where you see cases where the courts are willing, not doing anything, so the ICC will take the cases. As the ICC takes the cases, practically we're doing the opposite. We're encouraging, practically, national courts not to do the job, although they can be able. This comes with the idea of division of labor, so that ICC will take the big fish and will leave the lower fish. But if they are able and willing, and we're taking the big fish, as if we're going back to the problem of show trials, what Margaret Rumble talked about. We take the big guys with it. I think Kenya is able, and to a certain extent is willing. So also we go there, also where is the maximizing the impact for the court? Where we're going into places where the court is not maximizing that. What do you think about that?
Okay, thank you, Professor Shirky, about that. I think that about complementarity, I believe you will be in Kampala review conference, and there one of the stock-taking exercises will be exactly the issue of complementarity. So, as for now, the appeals chamber decided that the complementarity means that the court can intervene whether if the national system is unable or unwilling, or if the national system did not open an investigation. So they said, if there is no action, we can intervene. If there is an action, then we have to assess whether they are able to fulfill it or they are really genuinely willing to do it. But if there is no action, we don't need to have this assessment. So they are considering, in case the national system is remaining passive, the court can intervene. Now this is a part of the picture. The other part of the picture on which there's more and more debates is what's called the positive complementarity. So it's a kind of more cooperation with the national system and capacity building programs, etc. Of course, this is a large debate. As for now, at my knowledge, there are small efforts starting to build programs of cooperation with the national systems on different aspects. And I know that, for example, the registrar of the court is very interested in this kind of projects. So this is another type of complementarity and how we can encourage and help, not only encourage, but also help the national system to do this job.
The only issue is that in his prosecutorial policy paper, 2003, he mentioned proactive complementarity. That was in 2003. We are 2010. So it was parole. I don't know, but it did not materialize.
Yeah, but I know your critics about the prosecutorial policy, but at the same time, it's not only a decision for the prosecutor, because the prosecutor does not have also enough resources to build capacities in 4 or in 5 countries. It's not possible. So of course it should be an engagement for the whole court and for the whole international community, because the court should, in my opinion, play a role in helping joining the forces between different parties that can be involved in this process. It's not only up to the court. But as for the judicial process, the cases against specific persons, the defense can always plead or challenge the admissibility of the case based on the absence of the complementarity criteria, for example. But for now, the complementarity criteria does not mean only unable or unwilling, but it also means that first the national system has to open an investigation, to start a prosecution. If not, even if they are able and willing, but they didn't do it, we remain competent for that.
I think Sudan did not sign the Rome agreement or whatever. How were you able to open an investigation and Sudan is not part of the court? Why don't you do the same for Gaza, the same of what happened in Yemen, of a lot of places in the world? Why it is only that can happen in Sudan and cannot happen in other places?
Well, first, Sudan signed but didn't ratify the Rome Statute, so it's a different thing. Second, the situation in Sudan was deferred to the court by the United Nations Security Council resolution in the 31 of March 2005, and that's why the court has jurisdiction over Sudan, because Sudan is a state member to the United Nations, and so it's obliged by the resolution of the Security Council. Now, why the court did not open an investigation in Gaza? Because first, Gaza is not a state party, there is no referral by the Security Council, and as per the declaration of the Palestinian Authority, we need first to assess whether or not it fulfills the requirements. So we are at this stage.
Just to follow up on this question. Obviously, as eloquent as you were in presenting, especially the legal side and the structural side, The question, especially I think in this region of, and we talked a little bit earlier about the sort of, let's say, the political aspect or the politicization of the courts. Do you think, is it fair to argue that it's not a coincidence that the 5 countries that you mentioned that the ICC is working in, first of all are in Africa? Is this a coincidence? In the second case, if the ICC was not able to open in the case of Palestine, it could have opened in Lebanon or in any other cases where, let's say, pro-Western or the other side, not just some kind of, let's say, easy target within Africa. Is this something? Are these fair charges? There's a lot of criticism of the International Court and the skepticism. Aside from the legalities of it, and whether it's referred to by the Security Council, which of course already has its own political game and already is dominated by certain players, since the ICC has independence, I mean, I think I was correct, and you stressed the fact that the ICC is, in fact, of course, independent of the Security Council, and so therefore while Chapter 7 or otherwise may refer to the ICC doesn't have to necessarily prosecute as a result of this. And it can open its own investigation. So is it a fair criticism, and how is that being defended within the ICC?
Well, first of all, about the issue of African countries, it is a coincidence that 3 of the governments referred their own situations to the court. Yeah, of course. So the first 3 cases were referred by the African governments themselves. And the prosecutor had to take a decision whether or not to open an investigation, and he found reasonable basis to start, which was also the case for Sudan, but in this case the referral was by the Security Council and not by the government of Sudan. So the only case that the prosecutor started on his own was, in fact, in Kenya, and it was yesterday. So I don't think that the focusing on Africa is really a criticism that is really fair enough, especially that the court started from scratch 7 years ago or 8 years ago. So it's a very young institution at the end. But on the same time, we need to see that justice needs to serve the communities that are affected by the most horrible crimes. So first, we need to look and to see where the most horrible crimes are committed. And the African states were very supportive to the court, and now there is 30 African states that are states parties. It's the larger representation of any region of the world in their own statute, because they knew that they were suffering from this type of crimes, and the international justice needed to give a kind of answer to this request for justice. So this is one element of the answer. The other element is that the prosecutor is indeed examining other situations outside of Africa. Now, more in relation with the political aspects and the Arab region or the Middle Eastern region, I need first to say that all the proceedings before the court are based on legal criteria. So your question is not why are you doing what you are doing, it's why are not you doing enough in other parts of the world. So it's a kind, for me, I would like to understand it as a kind of trust in the court, or at least a trust in the need for an international justice to answer what's happening in this region. So, but at the same time, in order to have the international justice intervening in this region, we need first to give it the tools to intervene. So the jurisdiction. What's happening, why there is no investigation opened about Lebanon? Because Lebanon is not a state party. And that Lebanon did not declare accepting the jurisdiction of the court. It's only if Lebanon were a state party and referred the situation to the prosecutor, then we can start saying why the prosecutor is not doing what he has to do. But if Lebanon and the other countries in the region are not willing to refer their situations to the court, we cannot say the court is not doing its job in this region. Okay? So, in some way, I think first we need to explain the court to to the region, to the deciders, to build this kind of trust, and then we can judge how the court is functioning. And I have also to remind you again that the court started from scratch only in 2002. So, and already 5 situations with limited resources, with a very young institution is already a lot. So, of course, we need much more, but first we need much more trust from the region in order to work to serve it.
I would like to follow up on this question of the loopholes in international justice and this lack of universality of the ICC statutes, and tackle the question of this principle of universal jurisdiction. During the last months, one could follow the periphecies of Israeli decision makers having a hard time to visit the United Kingdom, and out of fear of being prosecuted for war crimes, according to this principle of universal jurisdiction. That says that basically some crimes are just so serious that any country has an interest in prosecuting this crime. So I would like to know more about the position at the ICC. How is this principle of universal jurisdiction seen? Is it considered as something complementary to the ICC, or how is it perceived?
I don't think there's no official position about this issue. It's a sovereign decision of each state to organize its judicial system as they want. But I can tell you that the idea of having a universal jurisdiction for the ICC is a goal, it's an aim, it's something that is motivating a lot of persons at the ICC, but this for us can be only reached if all the states join the ICC, but we cannot judge how the states organize themselves inside.